All right. The Parliament can make any law for whole or any part of India for implementing international treaties. Yes, written in the Constitution. Which article talks about it? Article 260 or 253, right? Yes, it gives the power. Interact, guys. Is it the right article? Aware, not aware? Are we reading the Constitution? Dead silence. Good morning, everyone. Say it loudly. Good morning. This is your loudness. Good morning. Good. Wake up call. So we have Article 253 where it empowers the Parliament to ensure that it can implement any international obligation, international treaty, even without the consent of the state. A PYQ, yes. Moving forward, then Rajya Sabha elections. We know that Rajya Sabha elections are held on the principle of proportional representation with a single transferable vote with open ballot system. Yes? Yes? All right. Anti-defection law does not apply to Rajya Sabha elections. So this is a judgment by the Supreme Court in Kuldeep Nair case, where it said that anti-defection law must not apply to the Rajya Sabha elections. That is also a reason because we follow open ballot system. Yes, we are openly, there is no need for going for defections. Then it is based on secret ballot. That is incorrect. Earlier it was based on secret ballot. But in which year it was switched to open ballot? पढ़ाई करके एग्जाम दिया आज. It was switched from secret ballot to open ballot in 2003, and in 2006 Supreme Court upheld that switch. Yes, a dispute regarding the elections to the Rajya Sabha is included in the original jurisdiction of High Court, not the Supreme Court. So this is also incorrect. Nota is available to MLAs for election to Rajya Sabha. Again, a judgment by Supreme Court, because this nota option is not made available to MLAs because it should be made available only to the general public. They are making or voting from the perspective of or on the responsibility given by the people of India. Yes. So there is no requirement for nota is available. That is incorrect. Only one would be the correct option. So for all the elections, whatever dispute is, the rationale is you'll go to the High Court. That is the original exclusive jurisdiction. Then if at all there is an appeal you want to make, then you can go to the Supreme Court. Yes. What rationale I can think is it might be to reduce the burden of the Supreme Court. Yes. All right. So A would be the right answer. Then moving on to third question, we are talking about central laws in scheduled areas and tribal areas. Which schedule are we talking here? You'll have to speak, guys. I'll slow down the class. We are talking about fifth schedule. Yes. Scheduled areas and tribal areas. And whenever we are talking about fifth schedules, all the parliamentary laws automatically applies. Unless the governor says some part or some law do not apply. Not in the case of sixth schedule. There automatically they do not apply unless the governor says that this part or this law applies. Yes. Governor of a state is empowered to direct that any particular act of parliament does not apply to scheduled area in that state. Yes. The President of India may by notification direct that act of parliament related to certain matters do not apply in autonomous district in case of Assam. That is by governor in case of Assam. So it is a little technical. It is governor in case of Assam and for other states of sixth schedule, which are Tripura, Meghalaya and Mizoram. It is the president. Yes. Go home and read these schedules properly. Read all these schedules for that matter. Please write down the homework. It might not suit our qualification graduates doing homework. But go home and read all these schedules, not just what does the schedule deal with, but in detail, just have a look at all these schedules. Also read the seventh schedule specifically about the 3 lists. Try to apply logic if at all possible, that okay, this is the reason why it has been allocated to the union list or the state list. But there might be certain questions, okay, this should have been in concurrent list, rather this should have been in union list, etc. Right? So those facts you will have to absorb. Ultimately, we are dealing with that we have to understand what the constitution says. There will be amendments down the line, etc. Our objective is to clear the prelims. Yes, then we can become a MP and change the constitution if required. Yes. All right. So this is incorrect. Only one would be the right answer here. Yes. Yes. Because these have been the 6 schedule areas. The reason for differentiation between 5th and 6th schedule is itself that the 6 schedule areas have not assimilated in a manner where 5th schedule area have been assimilated in a better or integrated manner. Yes. Yes. Explicitly written in the constitution. Which article talks about it? 71. Yes. Dispute related to presidential and vice presidential election. Okay. Then we are talking about federal issue, static question, written constitution, supremacy of the constitution, flexibility of the constitution. Flexibility means that constitution can be easily amended. When it can be easily amended, it will be moving towards unitary. Yes. So independent judiciary, one of the most important feature, one of the PYQ was, what is the federal feature, most essential federal feature? And if I have not mentioned earlier, there were multiple options which were true, but independent judiciary is the most essential feature, right? Bicameral legislature again, so only 4 would be the right answer. Then we are dealing with Digital Personal Data Protection Act. Have you dealt in detail? Have you read in detail? You should, if you haven't. Are we reading current affairs? Yes? Yes, no to bol sakte hain. Yes? Are we reading current affairs? Is there any person who is saying no? Please, this is the right time. The prelims has been postponed though. Yes? Don't let loose. Make sure if you are lacking in some areas where you are, let's say, in ethics, in your optional, etc. So you can do that parallelly, but you have already built a momentum through test series. Do not let it derail you, right? There have been certain instances earlier also, it was postponed during Corona time, during 2014 elections also. All right, but do not let it derail your preparation. Whatever your strategy is, try to complete that on time. And if you want to do something extra, then do that. Yes? All right. Act applies to processing of both digital and non-digital data. It covers processing of both because it will be eventually digitized. Give me the details. Okay, I'll make a star mark here. Write down question number 5 towards the end, first statement. For now, it is. So that is what we are talking about, right? It does not, according to you, it does not apply to all non-digital data. Okay, you will get it confirmed, right? It applies to the data that is being processed in India only. Is it the case? What is the exception? What is the exception? If at all, processing is happening outside, but they are targeting Indian market. Yes, they have their goods and services here, then it applies there. So, not always true because they are using the term only. An individual whose data is being processed has been termed as data principal. Yes, that is correct. So, only 2. I'll get it confirmed about the first statement. Then we are talking about interstate river water disputes. Act was passed under Article 262. Article 262 says that the Parliament, if required, can pass a act to regulate. And also it says in clause 2 that the Parliament can exclude the court from its jurisdiction. Yes. So yes, first one is correct. Then we are talking about prevent the Supreme Court or anything that is not President but Parliament. So this is incorrect. Water is the union list subject. Is it the case? It is the state list subject. And union list, when we are talking about water, that is interstate river water or river valley. So this is also incorrect. Only one would be the right statement. Yes. Then we are talking about Parliament can legislate on the state subject if at all the resolution is passed by the Rajya Sabha. Rajya Sabha passes a resolution under article. Okay, I'm waiting for response. Under article, around somewhere, article 1, article 350, article 249. Yes. I'll mention again, keep reading and referring to the Constitution of India. It is going to help you a lot, not just with article numbers. Only article numbers are not going to help. This might also help in your mains, but while you are talking, why I'm mentioning article numbers continuously, because then you'll go home and at least read this article. You'll not sit and read the whole Constitution in a go. And if you do that, you'll not be able to internalize anything. Yes. Please, at least for the articles we are mentioning here, go home and read those articles on priority basis. Okay. Now it says that such a resolution must be passed in Rajya Sabha by a majority of all the then members of the Rajya Sabha. Rather, it is the special majority, that is 2/3 of the members present and voting. So this is again incorrect. It is talking about which majority? Effective, but that is not applicable here. It remains in force for 1 year at a time. That is correct. Till the time such resolution is in force, no state can make laws on the same matter. Yes. That is not correct. Till the time such a resolution is in force, no state can make laws on the same matter. It is incorrect because it does not take away the power from state legislative assembly. Let me confirm this point. Because under one of these, under Article 249 or 252, what does Article 252 deals with? Anyone? Anyone? Under Article 252, two or more states give the power to the Parliament to make any law according for any particular subject. So in this particular case, it does not restrain under Article 249. The power also remains with the state legislative assembly. But when we are talking about Article 252, under which two states give the power to the two or more states give the power to the Parliament to make any law on any particular subject. Under clause 2, it is specifically written that this particular law passed by Parliament for any particular couple of states, it can only be modified and amended by the Parliament. Yes, not by the state legislative assembly. Correct. So this is incorrect. A would be the right answer. All right. Then we are talking about parliamentary system. The core of parliamentary system is, we have discussed that executive is drawn from the legislature and is responsible to the legislature, specifically Lok Sabha. Collective responsibility and individual responsibility we have read. So parliamentary system, when we are talking about parliamentary system, we are doing that because we preferred responsibility. Yes, over stability, which is a feature of presidential form of government. So it is not stable or less stable, so to say. Adheres to the principle of separation of power. Rather, it is taken from the legislature. So this is an overlap. Rather, wherever the executive is, executive, legislature, and judiciary. And judiciary are separate in presidential form of system. Yes, there is an exact overlap between the executive and legislature in parliamentary form. Yes. Judiciary is separated, so to say, but there are a lot of overlaps also. For example, judges are appointed by executive. Yes. They can be removed by legislature. Yes. So there are overlaps. And then judiciary has an overlap because it goes for judicial review of legislature and executive. Control of legislature over the executive. This is correct. Only one would be the right answer. Because executive is drawn from the legislature. So we are talking about a responsibility. It is collectively responsible to the legislature. For example, if at all there is a risk, they can pass no confidence motion. And then the government must resign. if they lose the majority anytime. But there is no such concept in case of presidential system about majority. Once elected, it will complete the term of 5 years. Yes, that is the difference. We are talking about Anglo-Indians. They are no longer nominated in Lok Sabha. Constitutional Amendment number 104th Constitutional Amendment. The term has been defined in the Indian Constitution. Yes, which article? Confirm this. I think it is 366 because it deals with several definitions. 6 only? Yes. 366, where it deals with various miscellaneous provisions. So, but this is not the right explanation. So, B would be the right answer. Then we are talking about money bills. Money bills, certain provisions are there under Article 110. What is the difference between money bill and financial bills, ma'am? Ma'am. So money bills deals with money matters, so to say. And financial bills deal with money matters plus other matters. Whenever there are other matters attached, it becomes a financial bill. Yes, and the process of passage, introduction, etc. changes altogether. There have been debates that why a particular bill was passed as a financial bill or as a money bill. Case of 2016-17 regarding Aadhaar Act. Yes. It can be introduced only by a minister. Yes. It can be introduced also with 110, read 109 as well regarding money bill. It can be introduced for payment into or withdrawal of money from contingency fund of India. Yes. Explicitly written under Article 110. So this is correct. First two are correct. What is the difference between withdrawal and appropriation? Article 110 talks about withdrawal also and also about appropriation. Different subsections are given. What is the difference? It has 2 points under 110. Consolidated also and contingency. So, good. Appropriation is withdrawal with a purpose. When we have a purpose, then it is appropriation. All right. The president cannot withhold his assent regarding money bill. He can withhold, but he cannot return the money bill. Yes. So this is incorrect. B would be the right answer here. Then we are talking about residuary powers, specifically given under Article 248, and it empowers the Parliament to deal with matters which are not mentioned in the 7th schedule, which are not mentioned or part of any of the lists. Yes, those are residuary matters, not covered anywhere. Have been given to the Union Parliament, yes. Constitution, this we have taken from Canada, not from Australia. 7th schedule also has a list of residuary powers. Then what is the point of having residuary powers? Yes, if it is with the Parliament and we have a separate list, it rather included in the Union list. So there is no list. The name itself suggests that residuary, which are left out. Give me some example. Cyber security, cryptocurrency. Yes. Placed residuary powers in the hands of Governor General. Yes. So this is also correct. 1 is correct and 4 is correct. So C would be the right option here. All right, moving forward then. We are dealing with 7th schedule 3 list. See, yet again, if you have read that particular schedule for that matter, if not logically, there might be certain exceptions in logic, so to say. Why is it with the center? Why is it with the state? But if you have generally gone through 7th schedule once, you'll be able to deal with such questions. And each question, each mark, each point mark matters. How many of the above subjects are part of concurrent list we are talking about? So bankruptcy, insolvency is with concurrent list. Cruelty to animals is with concurrent list. Trade unions, electricity is with concurrent list. Taxation on agriculture income. No, it is with the concurrent list. No, not with the 42nd Amendment. There were 5 things which were moved from state list to concurrent list. Those were weight measures, forest, education, Not electricity. It was already present in concurrent list. Okay, for that matter, how many subjects are there in different list? Union list, state list, concurrent list. (92). Which list we are talking about? Union list. What do you say? 90? 98? 97? 100? Yes, different constitution everyone is reading. Then state list, 59. Earlier 66 you are saying. And what else? Anyone else? Their constitution says what? 61. 61 were there. Once there were 61 as well, yes? And then what happened? Then hata diye gaye. Yes? Yes? 161 hai. Right? Okay. Then concurrent list, 52. That you have recently read from the book, yes? What else? Anyone else says differently? सबका constitution concurrent list पे agree कर रहा है? How is that happening? All right, the answer is 98, 59 and 52. Originally it was 97, 66 and 47. Then there have been certain additions and subtractions. From 97 it went to 100 and then 2 were repealed. It is 98 presently. Similar with 66, 5 were moved to concurrent list. It became 61 and 2 were removed. It has 59 now. 47 plus 5 is 52. Yes, it reads 97 still, but there are several 92A, 92B, etc. Yes, in total it is 98. Okay, then we are talking about taxes on agricultural income. That is given to the states. Whenever we are dealing with agriculture, largely it comes with state. Interstate quarantine, when we are talking about interstate, it naturally would be with the union. So these two are not with concurrent list, other 4 are there. Only 4. B would be the right answer. Go home and read the schedule properly. We are talking about Interstate Council. It was formed under which article? 262 or 3? Huh? Confirm karo. Which article talks about Interstate Council? 263, right? Confirmed? 263. ऐसे mini confusions better not create for yourself and the class. Interstate Council, it is a constitutional body. What does this article says? Is it mandatory for the president to create Interstate Council? What does it say? Whenever, if at any time president feels in the public interest there is a need for creation, it will not be illegal for the president to create such body. All right. So it says if at any time. Jab man kare. Yes. Established under 263, yes. And it was created in which year? पढ़ाई चल रही है या आज जैसे ही पोस्टपोन हुआ गिव अप कर दिया टोटली? I congratulate you for waking up on time and coming to the class after it being postponed. But make sure you are way ahead of the people who are relaxing presently. Rest assured with this. It is chaired by Prime Minister? Yes. It is chaired by Prime Minister or not? Chief Ministers are members and also the administrators for UTs. Its nature of duties, organization, procedure is decided by the President, specifically talked in the article. He might create and decide with the duties, etc. Recommendations are advisory in nature. Again, specifically mentioned in the Constitution. 1, 2 and 3. Then we are talking about Speaker of Lok Sabha. Which article talks about the Speaker of Lok Sabha, the office? My constitution says it is Article 93, that there shall be a speaker. Go home and look which article in your constitution talks about it. 93 only? Okay. Date of elections for speaker is decided by? Then what is the role of pro tem speaker? The office administers oath. Yes, oath of the speaker. He vacates the office when he ceases to be a member of Lok Sabha. Yes, that is the basic eligibility criteria required. That the person is elected from among the members of the house. Yes, may be removed by a resolution passed by a majority of all the then members of the Lok Sabha. Yes, this is we are talking about effective majority. Good. Must vacate the office immediately if the Lok Sabha is dissolved. So the office continues till the new Lok Sabha is in force and Speaker pro tem takes over. So this is incorrect. 2 and 3 are correct. B would be the right answer. So what I have noticed is, it is not that you don't want to speak. It is just that there is a knowledge gap. Make sure you have to fill that, complete that knowledge gap brick by brick. Yes, नीट लगाएंगे, पुल बनाएंगे. Yes, रोज एक लगाइए. All right. We are talking about Netto Plus, very much in current affairs for the last 1 year or so. Yes. Do read about what Netto is. Netto is, or Netto Plus is, Netto countries plus, how many countries? 5. Those are South Korea, Japan, Australia, New Zealand, and Israel. Yes. So we do not have India and UAE. So there was a lot of pressure, international pressure on India to join Netto Plus, but it has not yet succumbed to it. Okay. So only 5 would be the right answer. We are talking about working carried out through various tools and devices. Adjournment of a session while a bill is pending. And we are dealing with lapsing. Tell me the procedures, what happens. Let's say, when a bill is present or introduced in Lok Sabha and Lok Sabha is dissolved, then what happens? It lapses. When Lok Sabha passes the bill and it goes to Rajya Sabha and Lok Sabha dissolves, then it lapses. When Rajya Sabha passes a bill and goes to Lok Sabha and Lok Sabha dissolves, it does not lapse. It lapses. But if at all it has been introduced in a Rajya Sabha and has not gone to the Lok Sabha, it will not lapse. Yes, if at all joint seating has been called, notified before the dissolution, then it does not lapse. If the bill is waiting for the presidential assent, it does not lapse. There are certain bills and certain assurances with the Committee on Government Assurances. If those are present with that particular committee, it does not lapse. Certain exceptions are there. Right? What happens to motion for the removal of judge? Go home and read about it. It also does not lapse. All right. When there is a motion for removal, it does not lapse. Then we are talking about adjournment of a session. We know that when there is an adjournment sideline, or prorogation, the bill do not lapse. Any bill do not lapse, but it only lapse while there is a dissolution. Can lead to lapsing. Yes, only one, not the first 3. Moving forward, we are talking about borrowing of state and center. State can borrow from center or can borrow from external sources as well. Sure. And center? Center can borrow from states and from external sources. Please get clarity. State can borrow from outside, but not, center can borrow from outside, but not, state cannot borrow. And if at all state wants to borrow from center, it can borrow from center. So, but if it has already bought some amount and it is outstanding, then it will need permission again. Yes, mandates every state to take permission of the center for every borrowing, not for every borrowing. But when there is an outstanding amount, limits are decided by for center, the limits are decided by the parliament. Yes. And for state legislative assembly, for state limits, it is decided by legislative assembly. So B would be the right answer. जी बच्चे. Notify करते हैं, permission नहीं. That is their right. If they do not have any outstanding amount which is yet to be repaid, then it is their right. Yes? Okay. We are talking about 0 hours and question hour. Yes, important tools for ensuring the accountability of the executive. Unlike 0 hour, question hour is mentioned in the rules of procedure. Is it the case? Yes. Question hour is mentioned, but not 0 hour. During question hour, it can be asked only to the ministers. That is correct, because we are talking only. It can be asked with private members also. The question hour starts immediately after 0 hour. Question hour, then 0 hour. Yes. We are calling it 0 hour because, why is it called 0 hour? 12 बजे start होता है. Yes. All right. So this is again incorrect. Only one would be the right option. Then we are talking suspension. Quite a lot in news. We are creating new records each day with suspension of members. Okay. What is the difference between the suspension of members in Lok Sabha and Rajya Sabha? Raise your hand and talk. Raise your hand and ask for permission. Anyone? Anyone? Anyone else? Participative democracy? Yes, come on. Ma'am? Do you know the difference between the two? Yes or no? Tell me, no issues. लोकसभा एमपीज सस्पेंड किए जा सकते हैं एंड राज्यसभा एमपीज भी सस्पेंड किए जा सकते हैं, बट इनके प्रोसेस सस्पेंड करने में कुछ डिफरेंस है. पता है आपको? आर यू अवेयर? So, if we are talking about Lok Sabha and we are talking about Rajya Sabha, Speaker has all the powers related to the suspension of the members if the member is creating a nuisance, not coordinating. So, if the Speaker names the member, even by naming, the members remain suspended for the remainder of the session. But over here, the chairman does not have such powers. If he wants any member to be suspended, then a resolution must be passed in the house. Yes, these are all mentioned in the rules of the procedure of each house. So they can be suspended without passing a motion. Yes. Cannot attend meetings of committees, of course. When they are suspended, they cannot attend meetings for a maximum 2 consecutive session or for the remainder session only. So only 2 is correct, not for the consecutive sessions. So Speaker is empowered to suspend the members without any resolution. He just names the member and he stands suspended. But in case of Rajya Sabha, chairman does not have such powers. He would ask the Rajya Sabha to pass a resolution. If the resolution is passed, then the member is suspended. For example, Raghav Chadha. Yes, Raghav Chadha was suspended from Rajya Sabha because of several reasons. And then his suspension was revoked also by a resolution. Yes. So B would be the right answer. Moving forward. क्या? स्पीकर ओनली, दोनों के प्रिसाइडिंग ऑफिसर ही करते हैं, बट हेयर विद द रिजोल्यूशन. ओवर देयर आई थिंक इट इज विदाउट रिजोल्यूशन ओनली. ये एक बार आप कंफर्म करिए. लोकसभा एमपीज रिवोक हाउ टू रिवोक द सस्पेंशन ऑफ लोकसभा एमपी. अ मोशन इज रिक्वायर्ड और नॉट? व्हाट आई कैन रिकॉल इज अ मोशन इज required in Lok Sabha as well for revocation of suspension. Do confirm this with a star mark. All right. I would be happy if someone can mail me this answer as well. All right. Yes. Who will mail me? What's your name? Sudhanshu. Okay. Rohini Commission, quite a lot in news. We are talking about subcategorization of OBC. Yes. What is subcategorization, sir? Due representation to all the sub-communities within the OBC. That is subcategorization. Yes, for example, 27% is reserved for OBCs, for example. Then, within that, 5% should be given to this community, 10 to that, 3 to that, etc. Then how is it different from creamy layer? What is the difference between subcategorization and creamy layer? Creamy layer is basically the top economically well-doing layer within that category. And subcategorization deals with, it does not depend on the income levels. Yes, the benefits are penetrated to all the subcategories. All right, so A would be the right answer here. Moving forward, finance bill and money bill. For all the people who have committed a silly mistake and read it as financial bill, I have empathy. I have empathy for you. Yes, a lot of people did this because it was a PYQ. In the actual paper also, they were coming and debating regarding, sir, this is finance bill, you have taught this. But this is not a financial bill. All right, people who have committed this error, raise your hand proudly. Yes, up high. Yes, yes, go ahead. Up high. Great. Chalo. Errors here are totally accepted and rather congratulatory. Congratulations for making silly mistake here. Now you'll not forget it anywhere near future. What is the difference between the two? Yes. Financial and finance. Finance bill itself is a type of money bill. When the Lok Sabha transmits finance bill to the Rajya Sabha, it can amend or reject the bill. Now read all the finance bill as money bill. Can Rajya Sabha amend or reject the bill? So this is incorrect. When Lok Sabha transmits money bill to the Rajya Sabha, it cannot amend or reject the bill. It can only make a recommendation. That is correct. In case of disagreement, there is no joint seating for money bill. This is correct. But joint seating becomes necessary for finance bill, money bill. That is not necessary again. So only one, that is second, is correct. Then we are dealing with disqualification. Now there are various provisions in the Constitution which deals with the disqualification. Which article talks about disqualification here? And 191 specifically. Yes. And it empowers the Parliament to also pass law, if at all there are some extra grounds it wants to introduce. So Parliament introduced RPA as well, and it increased that list which was given in the Constitution with certain other provisions. Yes. We know in Constitution it talked about undischarged insolvent. It also talks about office of profit. Yes. So these two are definitely not present in, we are dealing with Representation of People Act. Yes, they are present in Constitution, not 4 and 5. My empathy is to people who have not stayed limited to this. Yes, error, proud error, raise your hand. Good. Failed to lodge election expense. Yes, this is listed as disqualification under RP 1951. Dismissed from state or central government service in case of corruption. Yet again, convicted for 2 or more years. Yes, so 1, 2 and 3. Only 3 would be the right answer, B. We are talking about cabinet committees. How many cabinet committees are there? Raise your hand and talk, do not speak. How many cabinet committees are there in total? Ma'am, how many cabinet committees are there? Ma'am, how many? Ma'am, who is avoiding me? Ma'am, how many cabinet committees are there? So total number is 8. Yes, earlier it was 6, but in 2019, 2 were added. One was investment and growth, and the other was employment and skill. So these were added later in 2019. Now they are asking which of the above are, what are the other committees? We have 5 here, 6 and 2 are left. Which are? Security they have not mentioned. Political affairs, economic affairs, accommodation. They have not mentioned appointment as well. Yes. So for all the committees are chaired by the Prime Minister except 2, which are accommodation and parliamentary affairs. All right. So we have 1, 2, 3. Only 3 would be the right answer. Yes. Then we are talking about parliamentary privileges. It is talked about in Article 105. Yes. So these privileges extend to AGI and ministers under Article 88, but not to Solicitor General. Go home and look, if you haven't already, what is Solicitor General of India. No criminal proceedings can be initiated against MP within the House without permission of the presiding officer. Yes, that is a privilege. No civil and no criminal. For that, you need permission of the presiding officer. They are immune from legal action for speeches made inside or outside the parliament. Outside is not covered, but inside, yes. For example, when we went to the new parliament So some flowery language was used by certain MPs, yes. Improved the or increased the, so to say, the privilege of the house. Char chand lag gaye. But because it was inside the house, no action can be taken. Yes, ma'am, you were saying something? It can be done. Oh, that is Article 361 exception. Yes. So again, only one is correct. Moving forward, we are dealing with Horizon 2047. And it is between which countries? India and France. What is Horizon? Should I stop asking questions? Okay, but you will not answer. I'll continue questioning, but will not answer, sir. What is Horizon, sir? Anyone? Please go home and read current affairs, for God's sake. This is the high time. You should have completed all this by now. I think it is about space and strategic cooperation in space, but with a star mark. Go home and look. How many of the above categories of the people residing in a particular state form the part of the electorate leading to legislative council? So, we are talking about MLCs. They are elected by 1/3 from MLAs. Yes, member of legislative assemblies vote and elect 1/3. Then 1/3 are from local bodies. Yes. Then we have 1/3, which is divided into 1/6 and 1/6. This 1/6 is nominated by the governor. Yes. And what happens to the rest? It is further divided into 1/12 and 1/12. And it has graduates and teachers. Teachers of minimum secondary grade. So members of the district boards, yes, because it comes under local bodies, but not primary school teachers, so this is incorrect. Elected members of legislative assemblies, yes. Members of municipalities, yes. 1, 3 and 4. C would be the right answer. Then we are talking about state legislative assembly has the exclusive powers when compared to state legislative council. What are the exclusive powers of assembly? So election of the president, that is the exclusive power of state legislative assembly. So all the members of the state legislative assembly participate in presidential election? Only elected members, yes. And a legislative council does not participate. Then ratification of constitutional amendment, only done by the legislative assembly, no role of legislative council. If we have to increase the jurisdiction of SPSC, we require legislative council, so it is not exclusive. Ordinances approval require legislative council. Ordinary bills passage require legislative. So these are not exclusive powers. So 1 and 2 would be the right answer, A. Then we are talking about distribution of revenues. We are talking about net proceeds. Constitution talks about net proceeds. Who decides and certifies the net proceeds? It is done by the CAG. A bill, I think it is mentioned in the part dealing with CAG itself. If you want me to confirm, let me do that. Just a second. 148, right? Just a second. We are talking about net proceeds here. Not with the CAG section. Just a second. Do confirm this. Is it given that it must be by the CAG? All right. Net proceeds have been mentioned several times within the Constitution. Calculation of 270. Yes, in the first clause itself. Yes, 279 clause 1 specifically given that shall be ascertained and certified by CAG. Good. Article 279. Just before Article 279A about GST Council. Yes, good. A bill varying the meaning of expression agriculture income can only be introduced on the recommendation of the President. Yes. The reason here is, why do we need presidential assent here? Because President is also elected by the state, and whenever there is a variation in the agricultural income, and whenever there is a bill regarding agricultural income, we would need the representative of the state. That is, whenever there is a federal issue, we would require prior recommendation of the President. Yes. So this is also correct. C would be the right answer. Reason is because we need prior recommendation of the President. And why we need prior recommendation? No, it is everything related with the agricultural income. Because agriculture is a state subject and he is a representative of the states also. He is also elected by the equal value of vote between the MPs and the MLAs. Yes? Yes? So head of the state taking care of the states also. So therefore, whenever there is a tax or agricultural income related issue, he must prior recommendation. Suno to bachche. Prior recommendation is required of the President. So C would be the right answer here. Then moving forward, we are talking about reservation of bill for the consideration of the President. We are talking about state bills. Which article talks about state bills? 200 and 201. It gives the special power to the governor to reserve the bills for the consideration of the President. In case of money bill, the President can return for the reconsideration of the state legislature. Even the President cannot return. He must withhold assent or give assent. Then ordinary bills President has sent for reconsideration. It is mandatory. If it is passed again, it is mandatory for President to give assent. This is not correct in case of state bills, but correct in case of parliamentary bills. Yes. So this again is incorrect. According to Constitution, it is obligatory on the part of the governor to reserve bills if it is related to amendment of DPSP. It is only with the changes in the High Court, domain of the High Court. That is the only obligation. So all we are looking for correct, none is correct. But not DPSP. That directive is totally different under Article 365. Then we are dealing with various features and description and Parliamentary Committee. Do not have representation from Rajya Sabha. Estimate Committee, yes, this is correct. How many members are there in the Estimate Committee? 30, all drawn from Lok Sabha, based on the recommendation of which committee? John Mathai Committee, yes. Set up on the recommendation of Krishna Menon Committee? COPU, Committee on Public Undertaking. Advises on matters that do not appropriately fall within the jurisdiction of any other committee. Yes, that is the reason it is called as general purpose. Yes, residuary type. Regulates the program and timetable, business advisory itself. So all four are rightly matched. D would be the right answer here. We are dealing with question number 31. Now we are dealing with the review of independent regulators. Review the independent regulators. What are the regulators for telecommunication? TRAI. Quite close. Yet so far, insurance regulator, IRDAI, electricity, stock market, SEBI. Yes. I think it should be for electricity, it should be CEA, Electricity Authority. Do confirm this, who regulates electricity. Then we are looking for who can review these independent regulators. Ad hoc committee by the Parliament? Yes. That can be a purpose given that you review this work of TRAI, for example. Departmentally related standing committee? Yet again. Finance Commission? That is not the role. What is the role? To determine the distribution of the net proceeds. Financial Sector Legislative Reforms Commission? That was a committee formed earlier, but that was outside its purview. Niti Aayog? It does not talk about it. So only 1 and 2. Then we are dealing with point of order. What is point of order, ma'am? When we are not following the rules of the House. Yes, then we can introduce the point of order. It relates to the interpretation or enforcement of the rules in the House. Yes. Minimum duration of debate is required. There is no debate required. So this is incorrect. Only 1. A would be the right answer. So this is your general understanding of things. It is not from any chapter, so to say. We are dealing with this. We are done. Okay. 33rd question. Administrative relations, full faith and credit clause. Constitution talks about this clause. Constitution talks about this clause. So it is talking about full faith and credit. How the government is run. Different organs of the state, executive, legislature, judiciary, etc. Whatever they are proclaiming, it is applicable all over India. In that proceeding, in that judgment, all should have full faith. Yes, specifically given under Article 261. It deals with the public acts, records, judicial proceedings and judgments. Yes. So all three are correct. C would be the right answer. Ji bache. If you have the understanding, that is more than enough. It does not matter. Should I stop mentioning if you want? It will help you in mains. Yes, article at times may matter so that you are able to simplify your knowledge. For example, we are talking about 249 and 252, the difference between the powers of the state legislative assembly if a law is made by the parliament. Yes. Leader of opposition. Is it a term mentioned in the constitution? Is it a statutory body? Yes, it is a statutory body given recognition in 77. Statutory recognition. Earlier, first LOP was elected or no, given the designation was in 1969. And there is a rule that 10% of the total seats of Lok Sabha or Rajya Sabha, the percentage must be at least 10% for the party in opposition with the maximum number of seats to be eligible to elect a leader of opposition. Yes? Clarity? This act mandates for a party to secure at least 10%. So this 10% rule, is it under the act? No. It is made by a rule by the speaker. This is known as Mavlankar rule. Made by the speaker Mavlankar. Yes. So this is incorrect. Leader of opposition is entitled to receive salaries, facilities of a cabinet minister. This is correct. B would be the right answer here. Then we are talking about Project Cheetah. We are dealing with a lot of. Are cheetahs present in India? If I ask this question 3-4 years back, were there any cheetahs in India? So they were extinct in 1952. And we had this dream of having or calling India a land of cheetah again. Yes. So our Prime Minister introduced the cheetahs. Yes. And we have several national parks where they are being introduced from Namibia and South Africa. Yes. All right. First intercontinental large wild carnivore translocation project from Namibia and South Africa. Any particular national park you can think of? Kuno National Park. Yes. Do read about where is Kuno National Park? When was it declared a national park? What are the different wildlife, flora, fauna, what is found in that area? Yes. You should be all aware of this. Then we are talking about 106th Amendment. All well, ma'am? Shaktiman ban gaya. Ab Nari Shakti Vandan Adhiniyam. Then it is for the reservation of women in Lok Sabha and State Legislative Assembly and Rajya Sabha, Legislative Council, PRI. All right. Only with Lok Sabha and State Legislative Assembly. Not Rajya Sabha, so this is incorrect again. Implemented after next census, one of the criticisms, so to say, whatever. Seats will be reserved according to respective population, SC, ST and OBC women. Yes? Not for OBCs. So only one would be the right answer here. Adjournment motion and censure motion. Let's have a look at. Both need the reasons for their introduction. Yes, there should be a reason given for introduction of censure as well as adjournment motion. While passing, censure motion will lead to resignation of the Council of Minister. No, this is not a no confidence motion, right? This will just censure the minister. So this is incorrect. Both the motions are mentioned in the Constitution. None is mentioned. Constitution does not talk about these motions. So only one is correct. Ji bache. Yes, reasons are required for both. Then we are talking about administrative relations. Under Article 365, which we were talking about recently, that president rule can be imposed if they do not follow the direction of the center. Yet again, 365 read with 356. President cannot entrust executive function of the union to the states without consent of the states. Is it the case? Is it the case? And if someone wants to designate a function, executive function, to the state without their consent, then second is wrong. It's right. So, president can designate the union functions to the states without the consent, right? No, yes, no? Yeah, no? Yes. So, they require the consent. Just a second. Entrust executive to the state without the consent. And they require consent here for sure. But if at all, if we want to designate any executive function, if done by parliament, there is no requirement of consent. That can be enforced directly. Yes, so this is the difference. Do not get confused. Both the statements are correct. Cannot entrust without consent. That is what we are dealing with. Just a second. Cannot entrust without the consent. Yes, so needs consent, no? Yes. It needs consent here. It is being done by the president. Then we are talking about deputy speaker. Who is the deputy speaker presently? No one. Lapata. Deputy speaker is nominated by the speaker from its members, from among its members. Nominated or elected? Elected from among its members. And the convention says he must be from opposition. So this is incorrect. Salaries are charged upon Consolidated Fund of India. Read the article 112. Yes. कल बोला था पढ़े हैं कि नहीं घर जाके? Yes. Mentioned in article 112 itself? Yes. Joint sitting is presided over by the deputy speaker in the absence of speaker. So when speaker is present, he presides over. When speaker is not present, deputy speaker presides. Yes. Clarity. And if deputy speaker is not there, deputy chairman. Good. And if deputy chairman is not there, senior most member. So it is decided in the sitting itself. Yes. So this is correct. Deputy speaker is required to submit resignation to speaker of the Lok Sabha. That is correct. And to whom the speaker submits his resignation to? Speaker. Speaker to deputy speaker. So presently there is no deputy speaker, so the speaker cannot resign. He'll have to continue. Yes. So in that case, speaker resigns to Secretary General of Lok Sabha. So 3, 2, 3, 4 are correct. C would be the right answer here. Then we are talking about setup for enhancing the center-state relations. These recommendations are there, and which of the following committee has recommended these? State should be consulted before bills on concurrent list. This recommendation, concurrent list related, governor should have a fixed tenure, and National Integrity Council. This was recommended by Panchi Commission. Yes. Written in your standard books, the recommendations are there. Yes. Read it properly or ignored it? Ignored? Totally? So the reason you are not able to recall is, जब पढ़ा था तो तेजी में पढ़ा था. You never knew when the Panchi Commission was formulated, when it gave the recommendation, and what was the context there, what was happening around. Yes. Do we know the timelines of these commissions? First one is? No. Which year? Sarkariya Commission, which year? Please go home and read these commissions. When were they formed? Who was ruling that time? What can be the context they came up with these recommendations? Yes. So B is the right answer here. Then we are talking about not correct. Yes. Not correct regard to control of Parliament on the budget. Parliament does not have any role in creation of budget. The budget is created by Ministry of Finance, Department of Economic Affairs. So there is no role. Has power to vote on charge expenditure? if you know this only, then you have got it correct already. Yes. No power to impose a tax without recommendation of the president. Yes. Then they cannot increase any tax. But can they decrease and abolish? They can decrease any tax or abolish. But they cannot increase the tax. The reason being, that is the domain of the executive. If executive says that, okay, we must introduce on a particular product 18% GST, then Parliament can discuss, okay, it should be not 18 but 28%. They can discuss about increase, but they cannot vote for increase. They can vote for, okay, we are recommending it should be 5%. Yes? So this again is correct. B is the wrong answer and also the right answer. Yes, we are looking for not correct. Then Rajya Sabha and UTs. Which of the above UTs have representation in Rajya Sabha? Delhi has how many MPs? 3. Puducherry, Jammu Kashmir, 4. Good enough. Chandigarh, 0. Ladakh, 0. So 1, 2 and 3, only 3. Yes. Then we are talking about zonal councils. Why do we have a map here? Okay, they have created the zones. This is, we are talking about which of the above statements are correct. They were set up under the State Reorganization Act of 1956. Yes, they are headed by Home Ministers, so not Prime Ministers. And Uttar Pradesh and Uttarakhand is in Central Zone. Not Northern Zone. Northern Zone is this green color. Go home and do it by mapping itself. I think it should also be present in your solution sheet. Yes, or otherwise you will Google, you will get it. So this is again incorrect, only 1. We are talking about union can legislate on subjects mentioned in the state list. Which of the following cases? When there is an emergency? Yes. Then 2 or more state request, again it can make a law on the state list, 252. President rule also? Yes. International agreements, 253. Yet again, so all 4 are correct. Moving forward. We are dealing about WTO. Green box, amber box, blue box. So what is green box? Sir? Nahi malum? Sir? Nahi malum? Anyone who is aware? So subsidies, if a government is, which are allowed because they are not distorting the market, that is green box. Yes. Unlimited subsidies can be provided. Yes. Subsidies are limited to, when we are talking about amber box, that is which distort the agricultural market, the international trade market. Yes. So there are limitations put on it, which are 10%. That is the reason we have several debates regarding MSP at the WTO negotiation table. So that is a problem for developing and developed countries. 1 point of skirmish. So this is also correct. Then we are dealing with blue box. Subsidies are limited to 5% of agricultural production. What is blue box? Which are market distorting. The subsidies which are market distorting. To minimize this distort, we put certain conditions. So this is amber box plus certain conditions. But there is no limit on the subsidies. So this is incorrect. 1 and 2 are correct. Only 2B would be the answer. Okay, they are asking incorrect. Great, thank you. Incorrectly matched. So we are only 1A would be the answer. Yes? Great. 46th question. Now we have the CSAT. For the question number 46, the answer would be C for 46th. And then for 47, the answer would be C again. All 3. Then for 48, the answer would be C again. CSAT में सब CC नहीं करके आना है. All right, do not be driven by emotions. Then we have A, immediate left off. You give due amount of recognition and acknowledgement to CSAT. Do not take it lightly. Even if you are a pro, you have cleared CAT with 100 percentile, etc. It doesn't matter. Right? It is a different exam, require different skill set. Then we are talking about 50th question. 50th is also A. All right. So that was it with the polity section. First half, we'll be continuing with the polity section. The second half in April. All right, you have the schedule already. Still till then, in the present test or in any other test,